Ready? Start. Testimony of PW4 and postmortem report oblique X PW4 oblique A remained uncontroverted as PW4 was not cross-examined. Stop. Thus, it stands proved that the deceased died of head injuries number 1 and 2 caused by a projectile which penetrated the brain from left temporal lobe and excited the brain from the right side of occipital region, causing fracture in the skull, and that both the injuries were ante-mortem and fresh before death, semicolon. The said injuries number 1 and 2 with the corresponding internal injuries were sufficient to cause death in the ordinary course of nature. Stop para. Postmortem report corroborates the version of eyewitness PW17 having seen the appellant shooting the deceased in head with pistol. Stop para. Recovery of pistol. Testimony of PW17 regarding the deceased being shot with the Katta oblique country made pistol is also corroborated by recovery of pistol XP1 at the instance of the appellant oblique accused pursuant to his disclosure X PW17 oblique D, in his presence, and that of PW25 and PW26, as discussed above. Stop. In view of their unimpeachable testimonies, recovery oblique production of country made pistol bracket open which was found containing one cartridge bracket close at the instance of oblique by the appellant oblique accused stood established. Stop para. Learned counsel for the appellant oblique accused argued that the alleged recovery of the Katta oblique country made pistol at the instance of the appellant is highly doubtful, as firstly no public person was joined at the time of recovery despite the fact that a temple was just a few steps away from the spot, and as per PW25's version, 4 to 5 public persons were present when the appellant oblique accused had produced the Katta. Stop. Further, no mud oblique dirt was found on the said Katta at the time of its production in the court, which falsifies the prosecution version. Stop. Further, the prosecution has failed to obtain ballistic report qua the alleged weapon, and as such, an adverse inference under illustration under bracket G of section 114 of Indian Evidence Act must be drawn. Stop. He also argued that no efforts were made to lift the fingerprints from recovered country made pistol, which is admitted by PW20. Stop para. It is settled position of law that non joining of a public witness is not always fatal. Stop. In Kripal Singh versus the State of Rajasthan under bracket 2019 5 SCC 646, the Honorable Supreme Court noted para. The submission of the learned senior counsel for the appellant that recovery has not been proved by any independent witness is of no substance for the reasons that in the absence of independent witness to support the recovery in substance cannot be ignored unless proved to be the contrary. Stop. There is no such legal propositions that the evidence of public officials unless supported by independent witness is unworthy of acceptance, or the evidence of the police officials can be outrightly discarded. Stop para. In the instant case, in view of the categoric testimony of PW17, PW25 and PW26, non-joining of public witnesses does not per se wipe out the recovery. Stop. More so, as PW25 and PW26 have explained that though 4 to 5 public persons present at the time of recovery of weapon, were asked to join investigation, they refused. Stop. Thus, non-joining of a public witness in the instant case, does not impact the credible testimony of the prosecution witness. Stop para. Examination report of ballistic division, FSL, Rohini, XPX1 on record has been admitted by the appellant oblique accused and inter alia records para. The exhibit marked F1 is a firearm as defined in Arms Act stop. It is a country-made pistol, capable of chambering and firing standard 8 mm oblique .315 caliber ammunition. Stop para. 18 mm oblique .315 cartridge received for test firing was chambered and successfully test fired through exhibit country made pistol marked F1 in the laboratory. Stop. Hence, it is opined that exhibit country made pistol marked F1 is in normal working order. Stop para. The physical examination of exhibit EC1 shows that it is an empty cartridge case of a standard 8 mm oblique 0.315 caliber and is a part of ammunition as defined in Arms Act, 1959. Stop para. No opinion be given whether the exhibit empty cartridge use case marked ECI is fired through the exhibit country made pistol marked F1 or not, due to the absence of prosecution cap. Stop para. From the above report oblique result of the examination, it is clear that the cartridge 8 mm oblique .315 was successfully test fired through the recovered pistol. Stop. However, no opinion could be given whether the empty cartridge case was fired through the said pistol due to the absence of the prosecution cap. Stop. Thus, it is not that the ballistic opinion was not sought, but the same could not be rendered due to the said reason. Stop para. As far as lifting of fingerprints from pistol is concerned, merely because no fingerprints from the recovered katta oblique country made pistol were taken, does not wipe out the ocular and other evidence including medical evidence which has come on record. Stop.